Hello, everyone. My name is Andrew Brown. I'm from Brown Lawyers. We are estate planning lawyers in Waterdown, Ontario. And this is a presentation about some experiences we'd like to share about estate planning during this COVID-19 crisis. This presentation is directed at estate planning professionals of all kinds, and really is to provide an update on just what the state of legal estate planning is. Really, the idea is to keep your clients informed, to be able to keep them served during this crisis, and to know what the options are, and to be able to set their expectations in trying to get things done during this time of crisis. Because if anything has showed us, this is not the time to pause and to take a break and all this stuff. If anything, these opportunities have existed and have been shown like no other time. Many of you are familiar with me. I've met many of you. Many of you probably, if you're seeing this and I haven't met you, I am taking this opportunity to grow out my hair because no one can give me a hard time about it, and it's going well. In all seriousness, I miss all of you. I hope all of you are doing well. Your businesses, your families are doing okay. Your clients are managing this time of uncertainty the best that they can. Really, I just want to share with you some practical challenges and identify some growing opportunities that we've been able to identify for all of us. I especially want to give a shout out to the Estate Planners Council in Hamilton. I was supposed to present to our group in April, so this is kind of in lieu of that, but it's just an opportunity to reach out and share with you what's going on. So here we go. So here's what the state is presently. Okay, so just to be clear, and I'm going to focus on the execution of the foundational estate planning documents, of course, the wills and the powers of attorney. Of course, this is what I just call, the legal estate planning documents. There's many other estate planning documents that all of our clients and estate planning tools that our clients need, but these are the ones that are mostly fall under our area as lawyers. But the idea here is signing is what I'm going to focus on, but I am going to talk about planning down the road. So right now, just like before, this is the situation. And this is what presents the challenges. The legal requirement that these foundational estate planning documents are to be signed in the presence of two witnesses. Of course, with physical distancing, with the bottom line practical health complications that are presented, with people wanting to be isolated, maybe because of their age or underlying health concerns. Having two witnesses present is a problem. It presents a barrier for people to get their stuff done. And so that's what we're left with. Of course, with wills, the Succession Law Reform Act still allows for holographic wills. I'll touch on that later. Powers of attorney, there is no holographic option. And just a reminder, if you're reading this about witnesses, is that the attorney that's referenced there, of course, attorney here in Canada does not mean lawyer. It means the person being appointed, the one that will be the legal representative. That's what it means up here. So don't get confused about that. Of course, the lawyer can still be a witness in these situations, provided that they are not the attorney that's being appointed. Okay, so this is what we've come up with. Remember, none of this has changed. This is still the law, but what has changed is there's now a temporary option for witnessing by video conference, okay? As part of the emergency legislation, orders and counsel that have been put in place, this has expanded witnessing by audio-visual communication technology, and it may be signed in counterpart. Early versions of this did not allow for the counterpart, and so it would have made it more difficult. And then we did get word finally that counterparts, and what counterparts mean is they can be signed on two different pieces of paper, but it's not until they are put together do we have one complete document. That's what counterpart is all about. And that's made a huge difference in how we roll all of this out. So just again, to be clear, these orders are currently only in effect for May 29th. Today, as I'm presenting this, this is May 21st. They are expected to renew for the duration of the state of emergency. Only Dougie knows how long that's going to go on for, but we don't see really an end in sight for that. But remember, this is only allowed right now during the state of emergency. One of the biggest changes about who can participate in this is that one of the witnesses must be a licensee of the Law Society of Ontario, meaning they must be a lawyer or a licensed paralegal. Those people have to be, one of those two professions need to be involved in all of this. Okay, so that's what this is all about. So how does this actually work? Of course, the video conferencing technology, audio, visual, it doesn't have to be Zoom. It could be any technology, any application, but Zoom is what we use most likely with us. Logistically, it's a challenge, okay, but it does work. The participants in the Zoom call must be the client or the clients. You know, if they're together or we're doing it in a multi-way video conference, one of the witnesses must be a lawyer or a paralegal, and then a second witness can be anybody else, okay? How this is working presently with our office, we're meeting with our clients over Zoom to get this signed up, and we're still coming into the office. A lot of some of our team want to come in the office, and so we're all in each other's bubbles, and so we're sitting together, and all of it's being recorded, and we're sitting in the same spot. It doesn't have to be that way. You could have the client in one spot on video, the lawyer in one spot, and the witness in another spot. It just adds to the logistical to complete it all. So the client's going to have the documents right in front of them. Either they're going to have printed them off, or they will be couriered from our office to them if they don't have the ability to print. Bottom line is there has to be some sort of assurance that we know what the document in front of them is, and they know what document is in front of us, making sure that we're all signing the same documents. And in the reality of it is, it's a matter of we record it. Every page is held up to the camera before it's signed, then they initialed, it's held back up to show the initial onto page 2. And we do that until it's all done, and then the witnesses will go through that. We then have a courier that the next day or the same day is going to be picking up those signed originals from the clients and bringing them to our office. And it's not until we put all of those documents together, both what the client signed and what we have signed as witnesses, that we do have a complete document. So you can understand here that it's a logistical challenge to do this, but it does work. We have developed an internal checklist that includes all the steps that must be taken pre-video conference, i.e. ensuring that the client has final versions of the documents in front of them, preparing the client to be sending them by a step-by-step guide, arranging for a courier to pick up the documents, details of the steps of the video conference, confirming ID, requesting permission to record the video, and then the steps that must be completed after the call, ensuring that the documents come back, return the originals as the client has agreed, on and on. So it's had a new process for us. We've relied on others. Anybody out there, lawyers, and obviously, if you want us to send you on our checklist that we've developed about this, just reach out. Happy to provide them. We rely on others, and so we're happy to pay it forward there. Just reach out to us and we'll provide you with what we're doing. In addition to this, the wills, the powers of attorney, we're including new language around this to address the situation, because the truth is it's going to look different than everything else that has been signed all the time up until this emergency time. And we can anticipate that this is going to cause questions down the road. You can imagine a situation with a power of attorney. It's difficult enough in the best of times to get a power for a client or an attorney for property to get a power of attorney document recognized by an institution, right? There's that due diligence involved. Now imagine a situation where someone goes to the bank on behalf of their mother or whomever, and now they're bringing them 2 sets of powers of attorney because they were signed during the COVID times, and that teller is going to, it's just going to be a natural reaction to go, whoa, 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 I've never seen this before. What's going on? It's just going to add to the extra delay. So what we're recommending is that once it's safe to do so, that anyone who uses this emergency process to sign up wills and powers of attorney, attend our office again to re-sign identical documents in the traditional way, okay? Although we have no reason to doubt that the documents we sign in this way are legally valid, we recommend this simply because it removes any possible debate down the road regarding the legitimacy of the documents based on the novel way in which they were executed. Bottom line is, it's the pragmatic approach to doing that. Even though they're legal, we want them to be recognized by anyone. What we're doing as well is during this time, we're doing extra affidavits of execution to make sure it's known that a licensee of the Law Society was one of the witnesses, as well as we're providing our clients with letters that can, to whom they may concern. If you're seeing two sets of powers of attorney here, but put together, presented as one document, this is why. And if you have any questions about it, welcome to contact our office. Bottom line is just try to smooth that process if they need to be used and we never got a chance or the client didn't come back to get them signed. So again, just taking a pragmatic approach and addressing, we have to think how these ultimately end up getting used as well. So there's that option there, okay? Here are some other options, right? So here's what else is on the table. We identified a self-guided sign up for some clients. These options are the least satisfactory in our opinion, but we can imagine that these situations where it might make sense, for example, for the self-guided sign up, someone who is self-isolating and does not have access to technology to do a video sign up, but does have people in their bubble that could be appropriate witnesses, this could work. The challenge here is that the client will not have an affidavit of execution attesting to the authenticity of the will, which will make obtaining a certificate of appointment after death just that much more challenging. And so we're recommending anyone who's done this to come in and sign up their wills in person as soon as possible so that we can overcome this challenge. Holographic will is there. So again, this is the least preferred option, but it is there. It exists under Succession Law Reform Act as a legitimate way to exercise that legal principle of testamentary freedom. It exists there for emergency situations. It exists there as a value of our society, that you don't need to go to a lawyer. You should always have the ability to change your testamentary wishes at any time. And so in your own handwriting, no witnesses required, signing, dating. In these situations, again, we don't recommend them, but if you can't get witnesses and you need to get something done, we have done it. We provide the text to a client, whether we mail them out, email them out, we do that, as well as basically sitting on the phone or something with them as they write it out and making sure that we know where it is, that they get it to us. And of course, once they want to come in and we got to get their, get it formalized. We don't want anyone left with this option only. However, it is there. If it kept it, I just always like to say, you're just going to buy an estate litigator or vote. And as much as we love estate litigators, God bless them, they can buy their own vote, frankly. Okay, so those are options there. So that's what the challenges with execution, addressing, on the planning as well, because obviously the planning part, the consultations, getting people the information, helping people make decisions so they can make informed choice. We used to always do that by face-to-face. And there's good reason for that. As we're all well aware, the vast majority of communication is nonverbal. And lawyers and other advisors of all sorts have been trained and have honed skills to be able to detect when someone is not being authentic, or that they are maybe lacking some capacity, or that doesn't seem that their instructions are coming from them, and I'm referring to undue influence, right? We are used to doing all those things in person, but now we're only doing those over telephone or video conference. And bottom line is, we have experienced is you can't take the same meeting that you would do in person and apply it to phone or video conference. You have to change it up to make sure that you are all the information that you think that you're conveying as an advisor and all the information that you think you're receiving is verified, because we're not able to pick up on those facial cues, those body language cues, the eye contact, all of those things. We can't pick those up in the same way. And so it just leads to a greater risk that they're not going to be reliable, that they are going to be subject to a challenge at some point. So we need to take extra steps to make sure that those risks are mitigated. Some of those have to be, we have to change and get bigger descriptions, and we have to do more verification. Obviously confirming everything in writing if you're a lawyer, providing the basic information that you do provide in writing. But also, and this is where the opportunities for all of us professionals to work together, now more than ever, for the benefit of our clients, we need to collaborate. Meaning we all have contact with these clients, they're all telling us, and we can work behind the scenes together to make sure that the instructions are clear. You know, helping, you know, if you get asset information from a client, you know, making sure you're talking to the financial advisor, the accountant, to verify that information, right? Talking about what the plan looks like, and so that we can compare notes to make sure that all in all, and when we do see disconnects, either in terms of instructions or knowledge of their assets or knowledge of family dynamics, to be able to pursue that, right? At least to be able to recognize that so that we can have a better outcome for the clients. Because all of the way things are now with the telephone and video conference, we have to make up for losing the ability to see people in person and getting the physical cues there. So all the more reasons to work on this together, okay? Some of it also has to do with the reality of our society's psychology dealing with this crisis. In my experience, one of the first things I noticed was when I was doing initial consultations right after COVID started to peak and become a much bigger deal in our communities, it seemed to be a lot more real to people. The will, the power of attorney, yes, people know that it's more of like something to check a box on their adulting. And, oh, I know I need to have this, but the actual application of them just seems so remote. It seems hypothetical, regardless of our understanding of mortality. Nonetheless, the idea that life can change so quickly now, it promotes focus on more effective planning, meaning all of this seems a lot more real. Bottom line is, I have seen more heart and emotion go into estate planning than before. It seemed more of a transaction for a lot of folks before. Now the reality of like, oh, this is actually very important and timely and real, okay? At the same time, you'll see here that we've made the point that we've also seen a lot of people pull back because they're overwhelmed with the basic day-to-day challenges about kids, about working, about finances, about you know, financial hardship, businesses being forced to close, the reality of a family dynamic who is now operating all under the same roof that maybe hasn't done that for a long time, and people just want to push that off. I think as estate planners, professionals, we owe it to ourselves, we owe it to each other, and we definitely owe it primarily to our clients and our community that we all need to promote healthy attitudes about estate planning, especially where people feel anxious and worried and overwhelmed. Estate planning is a healthy exercise. It is absolutely necessary. It involves all of us. When we have a plan, people's anxiety level goes down. When they feel covered, when they feel like they've been heard, their anxiety level goes down. They're able to be more productive. And I think we should be able to leverage all of this experience to be able to make estate planning less of a morbid discussion, something people want to avoid, where people should feel able to talk about it, because it should be as exciting as retirement planning, business planning, and it should be ongoing. And I think those are all the opportunities that exist now. We just have to adapt now to the reality of doing this in the ways that we can do this and seek out those opportunities. So thank you very much for hearing me out with all of this. I hope you found it helpful at all. If you want, get in touch. I would love to hear your feedback. I'd love to hear any other ideas about presentations about all of this. And bottom line, I hope all of you are well. And you and your families are doing well, and your clients, and keep on keeping on. And we wish you all the best from Brown Lawyers. Take care.